Hello, my name is Alice Richardson. I am a barrister at Trinity Chambers, and welcome to the first in a series of landlord and tenant webinars. I am going to look at possession proceedings in 2020 and potentially beyond today. My colleague Vilma Vodanovic is going to cover break clauses in leases, and then the last seminar will be from my colleague Tom Tyson covering forfeiture and rights of entry. Today we're going to cover possession proceedings in 2020. The situation has actually changed since I first proposed doing this topic as a live webinar back in November. And in fact, it's changed multiple times, and in relation to enforcement, continues to do so very recently, although luckily not at the pace of change that we had in the first lockdown. I'm sure none of us miss finding out from Twitter on a Friday night that there was new guidance, new practice directions, or new regulations coming into force the next day. So the talk today is going to cover notice periods, procedure for possession proceedings, and then enforcement. Looking at extended notice periods, first of all, then, Schedule 29 to the Coronavirus Act 2020 applies to all the tenancies that you can see on the slide now. And for notices served between the 26th of March and the 28th of August 2020 inclusive, the minimum notice period was 3 months. For notices served between the 29th of August and the 31st of March 2021 inclusive, the minimum notice period is 6 months, unless various exceptions apply. And all of the relevant notices, the prescribed notice forms, have also been amended online. Now, looking at the exceptions, first of all, in circumstances such as antisocial behaviour, domestic violence, or rent arrears, the tenant will be entitled to the following notice. The standard pre-extension notice period, where the landlord seeking possession on the grounds set out on the screen, the notice period reverts to the standard length for each tenancy, meaning that the extensions that I've just set out do not apply. The next exception, it gives 2 weeks notice period, and that is where a tenancy is assured and possession is sought on the grounds of an offence committed at a riot, domestic violence, or acquiring a tenancy as a result of a false statement, and that's the grounds set out on this slide. And then the next exception is the 4 weeks notice period. That applies where at least 6 months rent is unpaid in all the tenancy types I listed earlier, or if a tenancy is a regulated, protected tenancy and the landlord is seeking possession for antisocial behaviour. If the tenancy is a secure tenancy and the landlord is seeking possession for a conviction for an offence committed at a riot, domestic violence, or acquiring the tenancy as a result of a false statement. And lastly, the tenancy is an introductory or demoted tenancy and the landlord is seeking possession for reasons related to antisocial behaviour or domestic violence. Again, the grounds are set out on the slide. The next exception then is the 3-month notice period, and that applies when the grounds for eviction relate to the tenant's immigration status, so in practice where the tenant doesn't have the right to rent, or where the tenancy is an assured tenancy and possessions sought following the death of the former tenant. Lastly, just a quick note on Section 21 notices. The 6-month notice period applies to Section 21 notices from the 29th of August 2020. Assured tenants have been entitled to a minimum of 6 months, and Section 21(4)(d) of the Housing Act 1988 has been amended to extend the period in which the landlord can start possession proceedings from 6 to 10 months after service of the Section 21 notice for obvious reasons. There is an updated Form 6A available on the gov.uk website as well. Moving on then to procedure. The starting point today is that the general stay on possession proceedings, Practice Direction 51Z, ended on the 20th of September 2020. Under that practice direction, we all know the courts were required to suspend action on possession cases against tenants and homeowners and appeals arising out of those actions during the period of the stay. Any possession claim was automatically stayed and case management directions could only be given if both parties agreed. That practice direction resulted in 2 Court of Appeal cases, but what we now have is Practice Direction 55C, and that's essentially interim rules currently apply until the 28th of March 2021. Helpfully, as I'll go on to show you, there are different rules which apply depending on when the claim was started. Firstly, looking at reactivation notices. This is for the reactivation of claims for possession that were made before the 3rd of August 2020. So these rules apply to possession claims brought before that date where there was no possession order made prior to the stay. The claimant must serve a reactivation notice on the court confirming that they wish the case to be listed, relisted, or heard or referred to a judge. And paragraph 2.1 of the practice direction specifies that the reactivation notice may be served by any party. However, it's much more likely to be served by the landlord or mortgage lender. Unless proceedings relate to an appeal, the reactivation notice must firstly set out what the claimant knows about the effects of COVID-19 on the defendant and their dependents, and must be accompanied by an updated rent account for the previous 2 years if the claim is based on rent arrears. The reactivation notice must be served if a trial date was set no less than 42 days before the hearing, or in any case before 4 p.m. on the 29th of January 2021. If a claimant misses the deadline for serving a reactivation notice, the court will stay the claim, and the claimant will then have to apply to have the stay lifted. Obviously, if you've got a possession order prior to the 27th of March, you don't need to use a reactivation notice. Where case management directions were made prior to the end of the stay on the 20th of September, then in addition to the reactivation notice, the claimant must file with the court and serve on the defendant a copy of the last directions order, together with new dates for compliance with the directions, taken into account the stay. Either a draft order setting out additional or alternative directions which are required, or a statement saying that you don't need any new directions and that the existing hearing date can be maintained, and a statement in writing as to whether the case is suitable for hearing by video or audio link. If the defendant disagrees with any of the above, then they've got 14 days from service of the reactivation notice to file and serve their response. And if the claimant again doesn't comply by the 29th of January, the claim will be stayed. Where a claim was started on or after the 3rd of August, the claimant is not required to serve a reactivation notice. However, the claimant must bring to the hearing 2 copies of a notice setting out what they know about the effect of COVID-19 on the defendant and their dependents, and must serve on the defendant a copy of the notice no less than 14 days before the hearing. And if you're a social landlord, they must also bring to the hearing 2 copies of a notice setting out how they've complied with the pre-action protocol and serve a copy of that on the defendant. The accelerated possession procedure from the 20th of September is similar. Landlords of assured short-hold tenants can use the accelerated possession procedure to bring a claim for possession against their tenants. For claims brought on or after the 20th of September, the landlord must file a notice setting out what they know about the effect of COVID-19 on the tenant and their dependents, together with the claim form. And if the tenant disputes that evidence, the court may decide to hold a hearing rather than deal with it on the papers. So what then about court hearings in the interim period until the 28th of March? Where a hearing is listed or relisted as a result of the reactivation notice, the parties should, under the practice direction, receive at least 21 days notice of a review hearing. The Master of the Rolls Working Group has published a document entitled The Overall Arrangements for Possession Proceedings in England and Wales, which are worth a look at in detail. Under those arrangements, the court will schedule a review appointment and then a substantive hearing. The review appointment is called a review hearing, and there's no fee for it, and the parties don't actually have to attend court. What happens is the claimant has to provide the court with an electronic bundle or a paper bundle as an alternative, and to confirm to the court that a paper bundle has been provided to the defendant, or with an electronic version if the defendant is able to receive that. They must do that 14 days before the review date. At the review hearing, If the case isn't resolved by agreement, the judge will consider the bundle of documents that the claimant's provided and whatever else is on the court file. If the claimant's documents are all in order, the case will proceed to a substantive hearing 28 days later. If the claimant's documents are not in order, the court may dismiss the claim or may give alternative directions. The case might be resolved by agreement at the review appointment. If it's proposed that the tenant should give up possession, then a defendant, according to the overall arrangements, should not agree to this unless they've taken legal advice. How the defendant will know that if they haven't taken legal advice is not clear, but the overall arrangements document says that to ensure compromise is not deterred, local authorities are expected to take the approach that signing a consent order or agreeing to an order for possession in itself does not mean that the tenant or the borrower would be found intentionally homeless in a homeless application. Nevertheless, the defendant should not rely on that guidance, and legal advice will be available from the court duty advisor on the review date. Apparently, the court will provide details of how to contact the advisor. So that's the solicitors who have the duty advisor contracts should be available to a tenant on that date. For court hearings between the 23rd of August and the 28th of March, the standard 8-week period between issuing the claim and the hearing doesn't apply. Cases are being listed about 3 months ahead. A hearing date won't be fixed at the time that the claim form is issued. Turning then to enforcement. Going back to September 2010, at that time, Robert Gendrick announced that evictions wouldn't be enforced in local lockdown areas and there'd be a truce on enforcement over Christmas. That was at the time confirmed in the Master of the Rolls overall arrangement document, which said that the Ministry of Justice had issued guidance to ensure that no enforcement of possession orders will proceed where local lockdown measures are in place to protect public health, and other than in the most serious of cases over the Christmas period. There was then a further announcement on the 21st of October by the Lord Chancellor Robert Buckland, who wrote to the High Court Enforcement Officers Association requesting that no evictions take place in areas subject to the Tier 2 or Tier 3 local lockdown measures. Then, as we all know, on the 5th of November, the country went into a national lockdown, lockdown 2, and on the same day, the government announced a pause on evictions to protect those in rented accommodation during the national restrictions. And the stay was announced to last until the 11th of January, but there were some exceptions. So the exceptions were said to be illegal occupation, antisocial behaviour, being the perpetrator of domestic abuse, fraud, death of the tenant where the property is left unoccupied. And it was also announced an intention to introduce an exemption for extreme pre-COVID rent arrears. And the guidance that was issued to landlords at that time was that in order to protect against coronavirus transmission, bailiffs would not enforce a warrant for possession other than in those exceptions. The guidance at that time was that bailiffs would not enforce a warrant for possession in order to protect against the transmission of coronavirus during that time, other than those exceptional circumstances. It was also made clear that an agreement had been reached with bailiffs that evictions wouldn't be enforced nationally until at least the 11th of January, except in those most serious of cases. The Public Health, Coronavirus Protection from Eviction and Taking Control of Goods England regulations 2020 were laid before Parliament on the 16th of November and came into force on the 17th of November. My understanding is that those regulations were brought following receipt of a threat of judicial review on the basis that the previous method of enforcing of limiting enforcement of evictions by way of guidance to bailiffs. So we then had these regulations introduced, which put everything I've just set out really onto a statutory footing. The regulations apply in England only, and give legal force to the earlier requests made to enforcement officers and bailiffs to cease to attend at residential properties to carry out evictions or taking control of goods. Under the regulations, until the 11th of January, bailiffs are prevented from attending at a dwelling house for the purpose of executing a writ or a warrant or delivering a notice of possession, save in specified circumstances. And the regulations, Regulation 2 sets out those exemptions, and that is where the court is satisfied that the notice, writ or warrant relates to an order for possession made in the following cases. Firstly, cases against trespassers who are persons unknown, cases where the order for possession was made wholly or partly on the grounds of antisocial behaviour under Section 84A of the 1985 Act, ground 2, which is nuisance, ground 2A, domestic abuse, or ground 5, false statements in Schedule 2 to the Housing Act 1985. Ground 7A, antisocial behaviour, ground 14, nuisance, ground 14A, domestic abuse, or ground 17, false statements in Schedule 2 to the Housing Act 1988, or case 2, which is nuisance in Schedule 15 to the Rent Act. The other exemption applies is cases involving substantial rent arrears, where the unpaid rent arrears outstanding at the date on which the order was granted equate to at least 9 months of rent accrued up until the 23rd of March 2020. The exemption also applies to cases where the possession order was made wholly or partly relying on ground 7, which is death of the tenant in the Housing Act 1988, and the property is unoccupied at the time of attendance. All of that might leave open some questions in terms of how the bailiffs or the court will necessarily know that one of these exemptions apply. The guidance has been updated to say that new orders that are made after the 17th of November, the court should, if the order is satisfied that the case falls within one of those exemptions, record that in the order and specify which exemption applies. The guidance for a landlord is that if you want the court to consider whether your claim falls within exemptions for the extreme pre-COVID rent arrears, you must provide to the court and the defendant a detailed calculation of the rent arrears showing precisely how the definition in the regulations is met. The amount of rent arrears outstanding at the date must be, as I said, 9 months rent. Once any unpaid rent arrears accruing after the 23rd of March 2020 have been disregarded. If you have a possession order that was made prior to the 17th of November 2020, then landlords are advised to tell the court that their claim falls under one of the exemptions and should apply to the court to do so using Form N244. And the landlord must provide the defendant with a copy of that application. Apparently there is no fee to make that application. The application should be sent to the court that made the order. The court will list a hearing, and at that hearing it will declare whether it's satisfied that the possession order was made wholly or partly on one of the exempted grounds. If you have a warrant which falls outside of those exceptions, that will be executed when they can be enforced again. Realistically, not likely to be until maybe the 25th of January, because you have to give 14 days notice from the 11th of January. It's not entirely clear what will happen after the 11th of January, whether the position will revert to, if you are in Tier 2 or Tier 3, no evictions should take place in local lockdown areas. Only thing I can suggest is to keep on top of the guidance and keep on top of any further announcements. Thank you very much. That concludes today's webinar. I hope that it's been helpful.